Good
Assalamualaikum
morning.
warahmatullahi. Waalaikumsalam warahmatullahi wabarakatuh.
The Honorable Mr. Adrianto Dwi Nugroho, SH ADV LLM LLD, the Vice Dean for Academic, Students and Cooperation Affairs of Faculty of Law, Universitas Gadjah Mada. The Honorable Dr. Rimawati SH Hum, the Head of Study Program of Master of Health Law of Faculty of Law, Universitas Gadjah Mada. The Honorable Professor Roger Magnusson, the Professor of Health Law and Governance, the University of Sydney Law School. The Honorable Lecturers of Faculty of Law, Universitas Gadjah Mada, students of the Magister of Health Law and Faculty of Law, Universitas Gadjah Mada, and all students of other study program and graduates of Master of Health Law of Faculty of Law, Universitas Gadjah Mada. I'm delighted to welcome you to this guest lecture of the role of law in achieving public health objective. Let me introduce myself first. I am Nanda Christine Dwi Rahayu. I would like to be a master of ceremony in this morning. This guest lecture is held by the Magister of Health Law of Faculty of Law, Universitas Gadjah Mada. Ladies and gentlemen, before beginning the guest lecture today, let's pray together. Pray begin. Okay, enough. Now, as a moment to open the guest lecture today, we would like to invite the Vice Dean for Academic Students and Cooperation Affairs of Faculty of Law, Universitas Gadjah Mada, the Honorable Mr. Adrianto Dwi Nugroho, SH ADV LLM LLD, to give an opening speech. So, to the Honorable Mr. Adrianto Dwi Nugroho, if you please.
Okay, so thank you, Mbak Nana. Very good morning to all students, all participants, and good afternoon to Professor Roger Magnusson. Thank you very much for fulfilling our invitation to give a guest lecture for today. And on behalf of the Dean, we would like to appreciate your offer to give lectures to our students. And just some information, our Master of Health Laws program is relatively a new program, maybe less than a decade, and we are striving to push our students to compete with the others and push the study program also to
recording in progress,
more well-known abroad. So I think your presence today and maybe in the future also, if you will, then it would boost up and it would strengthen the collaboration with the University of Sydney, hopefully. So and hopefully sometimes you can go to Yogyakarta and go to our faculty. But unfortunately, maybe for today, you are only here virtually, right? So hopefully next time you will be able to come to Jogja and meet our students and also our dean and all of the staff members of our faculty. So again, very appreciate your presence today, and hopefully you will have a good lectures, and maybe to all students you can enjoy the lectures and ask questions to the professors while he is here. So thank you very much, and good luck for the lecture. Thank you.
Okay, thank you very much to Mr. Adrianto Dwi Nugroho for the wonderful opening speech. Ladies and gentlemen, now we come to the main agenda. The discussion and the lecturing would be proved by the Honorable Professor Roger Magnusson and will be moderated by Ms. Gisela Arden Samudiono, the students of Magister of Health Law of Faculty of Law, Universitas Gadjah Mada. Now, for Ms. Gisela, we would like to welcome you to open the main discussion today. The chance is yours.
Thank you, Mananda, for the kind introduction. Good morning, Pak Dimas, Pak Jeto, Bu Rima, and other lecturers, and my dear colleagues. Good morning, Professor Roger Magnussen. It is an honor for me to be here, and I would like to welcome you all to the guest lecture class for the postgraduate program, Faculty of Law UGM. Again, for a quick class rules reminder, Professor Magnussen's presentation will be delivered around 60 minutes. Then it will be followed by a discussion session for 30 minutes, which I will receive and try to read questions, as many as possible, both directly from the students and from the chat bar. And students are expected to activate their camera throughout all of the sessions. As we observed in Indonesia, currently cannot really be deemed as having a public health law yet. We indeed have the law number 36, year 2009 about health, and we know it is a politic product from the legislative body. Meanwhile, in other countries such as Australia, their legal system becomes the well-established source of public health law. And even more, Australia's health system is considered as one of the best in the world, providing safe and affordable health care for all Australians. It is jointly run by and commitment gathered from all levels of Australian government, federal, state and territory, and local. Today, we want to learn on how the concept of the public health law in Australia and the legal instruments which formed into the legislation system, citizens' response and involvement, especially during COVID-19 pandemic situation, which response were coming from all layers of society. Our speaker today is a distinguished professor from University of Sydney School of Law, who teaches on public health law, policy and governance, bioethics, and health development. His main research interests are also around those areas, including the prevention of non-communicable diseases. Not only that, if we remember one of those moments we have during our class in bioethics and human rights, where we discuss about euthanasia, the endless pro-cons, especially with what we have currently under our national legal system, I'm confident to say that we are very lucky to meet him today as the expert himself, having published a book about the practice of underground euthanasia in San Francisco, California, and Australia. Without further ado, please welcome Professor Roger Magnussen.
Terima kasih, Gisela. Selamat pagi ke Fakultas Hukum Universitas Gadjah Mada. Saya mau berterima kasih kepada Nanda Christine, Bapak Wakil Dekan Pak Adrianto Nugroho, sama Ibu Dr. Rimawati untuk kesempatan untuk ikut kelas kalian dalam hukum kesehatan masyarakat. Sayangnya saya harus berbicara dalam bahasa Inggris. Saya bisa memesan So thank you very much for the kind invitation and introduction. Let me just share my screen with you for a moment. Over the next hour, I'm going to be dealing with three topics. The first topic is, what is public health law? How do we define the field of public health law? The second topic is, where does public health law come from? What are some of the sources of public health law? And the third topic turns to the recent COVID pandemic and considers the role of law in responding to outbreaks of contagious disease with pandemic potential. The public health response to COVID in many countries has created an enormous body of law. Much of that law consists of highly detailed executive orders, public health orders, we call them. And those public health orders impose restrictions on people. They restrict where they can go. They require them to wear masks and so on. So I will talk a little bit about that. Okay, let's begin by talking about the field of public health law itself. Personally, I see public health law as a branch of the wider field of health law. Others may see the field differently, but I would say that within the broad field of health law, we can identify a number of different areas. Healthcare law, mental health law, public health law, global health law, and also a field that I call law and health development, the role that law can play in health development. Most of us, I think, are familiar with healthcare law or medical law. This is the body of legal principles that regulates the practice of medicine and regulates doctors, nurses, the healthcare professions. Healthcare law has a particular focus on treating patients when they get sick. Perhaps we should call it sick care law, but people often call it health law instead. But health law has a particular focus on individuals. Doctors treat patients one patient at a time. Public health law, on the other hand, is concerned with the health and welfare of the public generally. Public health law is interested in population health, the health of the public generally, not just individual health. And this distinction is very important. That's why public health law is focused on society. Public health and public health law are interested in a broad range of factors, including public policies that influence health. And those factors extend well beyond doctors and hospitals and healthcare services. The field of public health interacts with questions of public policy that fall outside of the healthcare sector, but which are still relevant to the health of the population. And this is one of the things that makes public health law controversial. It's also one of the things that makes public health law reform very difficult. Let me give you a couple of examples. If you're concerned about the harm caused by alcohol, for example, or by tobacco, you'll know that taxing these products is one of the most effective ways to reduce harm. But the health sector doesn't set taxation policies. Usually that's the job for the finance ministry. And the culture within the finance ministry is usually not focused on health. The finance ministry has its own priorities. In addition, in your country, you have a large and powerful tobacco industry that lobbies governments and tries to influence policies and laws. And in Australia, we have a large and powerful alcohol industry, and it tries to do the same. In all countries, tax policy is highly political. It's hard to raise taxes, at least in a democracy. In many countries, any political proposal to raise tobacco taxation will result in lobby groups which campaign the government, and those lobby groups will represent many different kinds of businesses, not only the tobacco companies themselves, but just about every, warung in the country that sells tobacco as well. Another way to reduce the harm caused by alcohol or by tobacco is to restrict advertising. Regulatory control over advertising usually lies with the Ministry for Communications, or perhaps with another ministry. But again, the Health Minister is unlikely to be able to introduce legislation to restrict tobacco or alcohol advertising without broad political support. And you can expect opposition from big businesses, but also from organizations that represent small businesses like this business that you see in the slide. As you can imagine, tobacco control is framed, it's represented by the tobacco industry as an attack on small businesses who rely on tobacco sales. And that's not the only problem. Let me give you an Australian example. In Australia, the alcohol brands also sponsor sport. This slide shows you one example. Victoria Bitter is a brand of beer. And if you watch football, you can see that the brand is constantly visible. In this slide, you can see that the football field itself has been prepared so that the brand of beer is visible when you watch television. And so the problem is that this kind of sponsorship helps to fund the sport. We used to have this problem with tobacco sponsorship many years ago, until all tobacco sponsorship was banned. But you can appreciate that when harmful products sponsor sport, it increases the opposition to evidence-based public health measures. So the point that I am making is that public health law is controversial and highly political, because public health law seeks to alter the way we live. It isn't only concerned with hospitals and the healthcare sector. It is concerned with society more generally. And there are often trade-offs to be made. Everyone knows that junk food is bad for you. But in Australia, junk food companies like McDonald's sponsor children's sports. They help to fund children's sports. And so if you ban McDonald's from sponsoring sport, you also undermine the economic foundation for children's sports. So I'll summarize what I've been saying so far. Public health law seeks to improve the health of the population. It interacts with questions of public policy that fall outside the healthcare sector. Implementing public health law reform often means seeking support from non-health ministries, and those ministries have their own culture, their own priorities. Public health law is often highly political because there are vested economic interests that have a stake in resisting law reform. And often there are trade-offs to be made. Policymakers need to balance public health with other considerations. Let's talk a little bit about how we can define public health law. One of the best known definitions of public health law comes from Professor Larry Gostin. Larry is a good friend of mine who is a professor at Georgetown University in Washington, D.C. in the United States. Larry's perspective on public health law comes from his perspective about public health. So, first of all, the field of public health has a focus on populations, according to Professor Gostin, rather than individuals. Public health isn't all that interested in individuals. Instead, it's interested in the population generally, or in groups of, it's interested in groups of people within society. Professor Gostin argues that your health and my health and everyone's health begins at the population level. You can buy a home and I can buy medical services, but neither of us can assure the conditions for our own health. You know, do any of you have children? I have 2 girls. They get sick at school. They bring their sickness home and then I get sick. You know, mereka batuk, mereka terkena pilek, kemudian saya terkena pilek. So none of us are self-sufficient when it comes to health. We are too interconnected with other people. And after the COVID pandemic, I think that this is very clear. Public health is a society for everyone, is a challenge. Public health is a challenge for society generally. It requires collective action that is led by government. The second feature of Professor Gostin's theory of public health is the focus on government. So for Professor Gostin, public health law is what the government does to protect health, rather than the private sector. The private sector has no legal power to regulate public health. Sometimes businesses can protect public health by not polluting. Sometimes businesses can encourage their workers to stay healthy. They can do good things. But ultimately, Professor Gostin believes that governments must lead the public health response, because only governments can resort to coercion where that is necessary. Coercion is a central concept in public health law. And that's because the protection of public health may involve restricting an individual's liberty or their privacy, or restricting the economic freedom that businesses have. Ultimately, public health policies must be backed up by the authority of the state, because otherwise you can't implement policies effectively. Without coercion, you have public health promotion, but you don't have public health law. And that brings me to the final part of Professor Gostin's theory, which is that this coercion brings tension. Now, in a democracy, governments are ultimately accountable to the people. And the legitimacy of laws, the legitimacy of public health laws, comes ultimately from elections and the mandate that we give our elected political representatives. Nevertheless, trade-offs between different kinds of public health or different kinds of public interest are a familiar feature of public health law. Do we restrict personal freedom? Do we restrict economic freedom? Do we restrict religious freedom to prevent the transmission of COVID? And how long do we do this for? How heavy are the restrictions? Okay, so these are the main points that I wanted to make about a definition of public health law. Before I continue, I want to make one further point. In Indonesia, you probably think of Australia and the United States as very individualistic societies. It's as if our perspective of society is built on individuals' rights. And the role of the law is to protect the individual from infringement of his or her rights by the state, so that there is room for each individual to grow and to flourish. Often when we debate public health law, we find reasons to argue that the law should not intervene. So if we talk about tobacco control, or if we talk about using law to require better food labeling, some people will say, well, that's not a matter for government intervention, it's a matter for personal responsibility. And that's a common argument in highly individualistic societies like Australia and the United States. But it's important not to think about population health only in terms of personal responsibility by individuals. Businesses that pollute, businesses that sell harmful products benefit from this attitude, from this tendency to think about public health only in terms of individual responsibility. The population focus is very important. There's a difference between the field of public health law and the field of lifestyle medicine. Personal responsibility is a great strategy for personal health, but it's not a very good strategy for public health. If you want to avoid getting holes in your teeth, you need to brush your teeth. This is a picture of my daughter when she was 3 years old, and we were teaching her to brush her teeth. That's a good thing to, to teach a child. That's lifestyle medicine. But if you want to improve dental health at the population level, the most powerful thing to do is to put fluoride in the water supply. That's public health. That's public health policy. So you can see that lifestyle medicine is very different from public health policy. Public health policy has a population-wide perspective, and we shouldn't eliminate public health policy by placing all responsibility on the individual. Okay, that brings me to the next part of my talk, which is about where does public health law come from? All of us, I think, can identify some laws that we might call public health laws. This slide shows you the National Parliament building in Canberra in Australia. Australia is a federal system, so we have a federal government, and we also have state governments and territory governments, as well as, I think Gisela said. Each of the states has its own public health act, And those acts deal with a range of matters. I won't read them all out, but you can see them in this slide. Things like tobacco and alcohol control, food safety, public health emergencies, notifiable diseases. We also have a number of acts at the federal level that control aspects of public health. So we have national standards for poisons. We have regulation of therapeutic goods. Alcohol and tobacco taxation in Australia are a matter for our federal government, not for our state governments. And there are many other examples that I could show you. So legislation is perhaps the most obvious source of public health law. I'm sure that in your country too, you can find examples of legislation, and you might say, well, that's really public health legislation. It protects the health of the public. One example, interesting example of national tobacco control legislation that you may have heard about in Australia is the Tobacco Plain Packaging Act, which restricts the use of trademarks on tobacco packages. Many years ago, tobacco packets in Australia looked like this. But over the years, government introduced larger health warnings, and then they introduced what we call graphic health warnings, words and photos that warn about the dangers of smoking. And then in 2011, Australia passed the Tobacco Plain Packaging Act. And so this is what tobacco packages look like in Australia now. Plain packaging legislation prevents the use of trademarks on the tobacco package. And so tobacco companies cannot use the package in order to advertise the intangible values that companies like to advertise through their brands. A number of countries, including Indonesia, actually brought a World Trade Organization complaint against Australia, arguing that this legislation was inconsistent with the World Trade Organization agreements, including the agreement on technical barriers to trade. But now a number of other countries have also begun to introduce tobacco plain packaging legislation, and you will see more and more of it around the world. I don't want to focus too much on legislation, but I think it is the most obvious source of public health law. So where else does public health law come from? Other sources of public health law that we need to be aware of include international law. They include constitutional law, not to mention the decisions of courts and tribunals. So I want to spend a few minutes now talking about international law as a source of public health law. And then I will give you a case study of how constitutional law can have an impact on public health. Treaties, I think, are the most obvious source of international public health law. The World Health Organization itself is an international organization that was set up under a treaty. In 1946, 61 countries, 61 states signed the WHO Constitution. And since 1948, the WHO has operated as a specialized agency of the United Nations. Currently, there are around 194 member states of the WHO. The preamble to the Constitution of the World Health Organization states that the enjoyment of the highest attainable standard of health is one of the fundamental rights of every human being, without distinction of race, religion, political belief, economic or social condition. In fact, Article 1 of the WHO Constitution states that the objective of the organization, the purpose of the WHO, is the attainment by all peoples of the highest possible level of health. The World Health Assembly is the supreme decision-making body of the WHO. It consists of delegates from the member states. The World Health Assembly has the power to make treaties or conventions, as well as regulations. So Article 19 of the Constitution empowers the World Health Assembly to adopt conventions. Article 21 empowers the World Health Assembly to adopt regulations and also to make recommendations under Article 23. Now, the best known example of a convention that impacts public health is the WHO Framework Convention on Tobacco Control, which entered into force in 2005. So this is a very important source of public health law. There is also a protocol to that convention called the Protocol to Eliminate Illicit Trade in Tobacco Products, which entered into force in 2018. The best known example of regulations are the international health regulations, which provide the legal framework for the global management of pandemics. So the international health regulations, or we call them the IHR, the International Health Regulations, IHR, were revised after the SARS epidemic in 2003, and the revised international health regulations became legally binding on member states of the WHO in 2007. The IHR impose a number of obligations on WHO member states. These include an obligation to create a national focal point within the country who is accessible at all times to communicate with the WHO. The IHR also require WHO member states to assess events occurring in their territory and to notify WHO of all events that may constitute a public health emergency of international concern, using the decision instrument contained in Annex 2 of the regulations. Now, I'm showing you that decision instrument that countries must use in order to determine if there may be an outbreak of a public health emergency of international concern that is reportable to the WHO. Determining if a public health emergency of international concern does in fact exist is it's the responsibility of the Director General of the WHO, after seeking advice from the Emergency Committee. But if the Director General decides that a public health emergency of international concern does exist, then the Director General can issue temporary recommendations after receiving advice from the Emergency Committee. Some of you may know that as everyone knows, I think the international health regulations have failed to protect the world from the devastating COVID pandemic. But some of you may know that in a special session of the WHO in November and December last year, the World Health Assembly decided to establish an intergovernmental negotiating body to draft a WHO convention or agreement or other instrument on pandemic prevention, preparedness, and response. So the WHO, the World Health Assembly, has already decided that this will be a World Health Organization instrument rather than a treaty that is negotiated under the broader United Nations system. And so far, the Intergovernmental Negotiating Body has also decided that the new instrument will be legally binding on states, but we don't yet know what form it will take. It might be a treaty, it might be regulations, but we know that it will be legally binding. The negotiating body will meet again in December, so just in a few weeks. Now, if I can just put something into the chat. I think I have to stop sharing my screen in order to put something into the chat. You can see a link to the latest information about this new convention on pandemic preparedness and response that is under consideration by the Intergovernmental Negotiating Body. Okay, so we've been talking about international health law as a source of public health law, and I've mentioned some examples that relate specifically to the WHO. But the right to health is also found in many other international agreements that impose legal obligations on the states, the countries that are parties to those agreements. One very important human rights treaty is called the International Covenant on Economic, Social and Cultural Rights. This is a major UN human rights treaty, and the covenant recognizes a right to health. So international human rights law, in other words, is also an important source of international public law, international public health law. There is a very extensive commentary about what the content of the right to health is and what countries need to do in order to comply with their obligations to protect and respect and fulfill the right to health. For example, the Committee on Economic, Social and Cultural Rights issued what is called General Comment number 14 in 2000. So this is an authoritative commentary on the scope of the right to health under the International Covenant on Economic, Social and Cultural Rights. I want to turn then from the concept of international health law to the slightly broader concept of global health governance. treaties and regulations as sources of public health law are quite rare, but there is a very large body of international instruments that deal with the management of globally significant health problems. And that's what we mean when we talk about global health governance. We're talking about the management at the international level of globally significant health problems. Global health lawyers like Professor Larry Gostin and others, when they talk about global health law, they don't only talk about conventions or regulations, they also talk about what are called soft law instruments. So soft law really refers to normative standards that have persuasive force, but they're not binding under international law. So this idea of soft law instruments includes many, many things. It includes the resolutions of the World Health Assembly and the UN General Assembly, but it also includes the technical products of the World Health Organization. And by that, I mean recommendations, principles, guidelines, action plans, codes of conduct, and technical reports on many different kinds of topics. It also includes the reports of expert commissions. For example, back in 2014, the Director General of the WHO established the Commission on Ending Childhood Obesity. So the commission consisted of a high-level committee that produced a report that contained recommendations for what countries can do to reduce childhood obesity. Now, the main committee was supported by 2 working groups, and I had the privilege of co-chairing one of those working groups. So it was a very interesting experience. But the point I'm making is that the recommendations of this commission, they're not binding under international law, but they have very considerable influence on countries. They have a powerful legal impact because they provide the catalyst. They are the catalyst for the creation of new laws at the national level. So these soft law instruments don't need to be legally binding themselves under international law in order to have a powerful legal impact on countries. They are what we call normative documents. Now, I also want you to be aware of forum sharing and the fact that there is deepening cooperation in health matters between the World Health Organization and other UN agencies. So at the top of this slide, you will see the UN building in New York, a very familiar sight, I think. Let me show you one example of what I'm talking about. The Global Action Plan for Healthy Lives and Well-being was issued in 2019. And it looks like a WHO normative document. But in fact, 8 UN agencies and 4 other global agencies have all cooperated in this plan. All these organizations have come together to accelerate progress towards the health-related sustainable development goals by coordinating under under 7 programmatic themes. Okay, I've talked a lot about international law as a source of public health law. I want to talk now a little bit about constitutional law as a source of public health law. And I'm going to talk about an American constitutional case called Roman Catholic Diocese of Brooklyn and Cuomo. This case, Roman Catholic Diocese of Brooklyn and Cuomo, considered what is called the free exercise clause of the First Amendment to the United States Constitution. Part of the First Amendment says, Congress shall make no law prohibiting the free exercise of religion. As you know, human rights guarantees, where they appear in national constitutions, can impose limitations or constraints on the power of Parliament. They can prevent Parliament from passing certain kinds of legislation. And they can also limit the kinds of executive orders that can be made. Now, in many cases, the protection of human rights also strengthens public health. Just to give you one example, freedom of speech is extremely important in protecting public health because it enables the media to demand government accountability. It enables people to demand that governments take actions to protect the health of the population. It enables them to demand better publicly funded healthcare, better access to pharmaceutical medicines. So usually, health and human rights are aligned, but sometimes they're not. And this is partly because health is only one of many values that are protected in the Constitution. In the United States, the First Amendment protects freedom of speech, but it also protects freedom of religion, as you can see. And so the case of Roman Catholic Diocese of Brooklyn and Cuomo illustrates the tension between freedom of religion and the use of emergency powers to protect public health. In October 2020, in response to the COVID pandemic, the governor of New York, Governor Andrew Cuomo, signed an executive order which placed restrictions on the number of people who could gather together in places of worship, churches, synagogues, mosques. Didn't matter what kind of place of worship it was, but the restrictions applied to every place of worship. Now, as you can see from this slide, in red zones where there was high levels of COVID transmission, no more than 10 people could enter a church or a mosque or a place of worship. The purpose of this executive order was to prevent the spread of COVID-19 during religious services where people were sitting closely together or praying closely together. But a Jewish organization and a Catholic organization sought an injunction against this executive order on the basis that it violated the free exercise clause of the First Amendment. So these organizations said, we have a constitutional right to practice our religion, and this executive order prevents us from doing so. So you can see that it created a contest between public health, preventing transmission of COVID, and religious freedom. Now, in this case, Roman Catholic Diocese of Brooklyn and Cuomo, the United States Supreme Court struck down Governor Cuomo's orders by a 5-4 majority. The majority opinion was very short. The majority justices said that the governor's executive order was not neutral towards religion, because although a synagogue or a church or a mosque in a red zone could not allow more than 10 people to worship at a time, that restriction didn't apply to a range of other businesses. So the first step was that the Supreme Court said, you're not adopting a neutral attitude towards religion, you're singling out religion for harsh treatment. So since the governor's orders, since the executive order was not neutral, the majority of the Supreme Court said that the government had to show that the governor's order, which interfered with religious freedom, was as narrow as it could be while protecting the public interest in protecting health. And according to the majority justices, the governor could have imposed a law which was less restrictive. For example, it could have linked the number of people who could attend a religious service to the size of the church or the mosque or the synagogue. So if you had a very large church or a very large mosque, then more people could worship there. But the problem with the governor's orders was that, as you can see, if you were in a red zone, no more than 10 people at a time could worship in the church. It didn't matter how big the church was. So the executive order was struck down. The Chief Justice of the Supreme Court dissented. He thought that the court should respect the decisions made by public health officials about what was necessary for public safety in the middle of a deadly pandemic. He said, and I will quote what he said, "Our Constitution principally entrusts the safety and the health of the people to the politically accountable officials of the states to guard and protect." So the decision of the Supreme Court in Roman Catholic Diocese of Brooklyn and Cuomo is one of a number of decisions in which the Supreme Court of the United States has struck down executive orders that were intended to prevent the spread of COVID-19. That does have an impact on public health. Overall, compared to other countries, the United States has done very poorly in preventing deaths from COVID. Rates of death in the United States from COVID have been very high, much higher than many other countries, much higher than Australia, much higher than Singapore, much higher than many other countries. And this is partly because of the way that the Supreme Court has adopted strict scrutiny of public health orders. Even though public health laws may be controversial, there are standards and principles that we can apply to ensure that the balance between different public health interests is appropriate. And this slide sets out some of those principles. This slide is adapted from the Siracusa Principles. The Siracusa Principles were developed by the UN Commission on Human Rights to identify circumstances in which governments could legitimately restrict the human rights contained in the International Covenant on Civil and Political Rights. So these principles require that when laws are introduced that restrict your freedom or mine, those laws should be capable of reducing the threat, and they should be proportional to the harm that the law is trying to prevent. Trust and transparency are also important. The public should have the opportunity to participate in making public health laws and expressing their views on public health laws. And when personal freedoms are restricted, then reasons should be given. In Australia, the restrictions on freedom of individuals during the COVID pandemic were very controversial. In fact, in 2020, police riding on horseback entered the grounds of the University of Sydney and arrested protesters. The photos that you can see are, very close to my office. They're only 100 meters away from my office where I am at the moment. One of my colleagues, who you can see in this slide, Professor Simon Rice, took his students to observe one of the anti-COVID demonstrations, one of the anti-lockdown demonstrations. And the police thought he was a protester, and you can see them pushing him down and arresting him. In a democratic society where the rule of law operates, I think we need to give our politicians a margin of operational space to design and implement laws to prevent the transmission of terrible diseases. It's unrealistic to expect governments to get everything perfectly right all the time. On the other hand, the problem in my home state of New South Wales is that the Public Health Act places no limitations at all on the emergency powers of the health minister. So there is no legal requirement on the health minister when he or she makes a public health order to balance the restrictions that they are imposing on the public against other competing public interests. There is no requirement on the health minister to ensure that the restrictions are as limited as possible. And that's one reason why COVID laws become so controversial, especially when the restrictions go on for many weeks. In concluding my talk to you today, I want to go back to the issue of how we define public health law. Although it's helpful to have a working definition of public health law, in many cases, I think it's very, very clear what the priorities are and what society ought to do, what our elected representatives ought to do. And we need to hold them accountable to ensure that they protect the public health. So even though we can debate the meaning of public health, usually I think it's very clear what some of the public health priorities are. Things like improving access to medicines for all members of the population, not just rich people. Motorcycle accidents and motor vehicle accidents caused by alcohol or by speeding or failing to use helmets. We certainly need to stand up to companies that make money, that get rich by selling tobacco. These companies don't deserve your respect. They just make your society weaker. And we need to ensure that everyone, wherever they live, can get access to quality healthcare services. These are just some of the many priorities, I think, in public health law. And so as public health lawyers, I think we all have a role to play in trying to hold governments accountable for their responsibilities under the right to health, so that we can all live in a healthier society. So the final point that I want to make is that we've talked a little bit about what public health is, but I don't think we need to get too theoretical when it comes to public health law. We just need to look around us. Thank you, Gisela. That's my talk.
Thank you so much for the outstanding presentation, Professor Roger Magnussen. A few points that we have learned from your presentation, if I may deliver a little bit, is about the public health law that concerns on population rather than as individual, as it's also argued by Professor Lawrence Gostin. And also it's interesting that we have learned about the importance of the government role that can always resort to coercion and restricting on the individual liberty owned by the citizen. And also, second point we have learned is also about the source of public health law, which obviously coming from the legislation, and second from international law about the WHO Constitution and IHR, also from the ICSER. And we have learned also about the importance of soft law or normative documents, which are not legally binding for countries, but show significant commitment. And it has powerful legal impact that one formed global health governance and has influenced countries' internal legislation system on public health law. Also, the source of public health law are coming from constitutional law and judicial decisions, which we have also learned about the interesting case law of Roman Catholic Diocese of Brooklyn versus Cuomo in 2020. And we know that it has contradicted, I think, the case law on Jacobson in 1905. And still, the Jacobson law, a case law, has been the key precedent supporting vaccine mandates and other public health laws, and it has also served as a reminder of the importance of public health evidence and the fact that real liberty cannot exist in the absence of reasonable restraints to protect the public health. I think that was the point from your presentation, Professor Magnussen. And I will kindly invite the students to ask for questions for Professor Magnussen. Is there anyone who wants to ask questions for Professor Magnussen?
Okay. Me.
All right. I see here Pak Sharofi.
Thank you.
Yes.
Good morning, Professor Roger. I want to three questions to you. Question number one, why does evidence in medical law case tend to be ineffective when an expert from the medical professional? If the legal action were carried out by a doctor. Number two, the right of the community to be heard in the public sphere, which has been regulated in the Constitution in Indonesia, but the intended achievement have not yet shown satisfactory result. What do you think is the case of the profession about Australia? Number three, is the smoke coming from Indonesia in bordering and bordering neighboring countries is public health emergency international concern? If so, what are the legal consequences of the government? Thank you. Yes, sir.
I found it a little bit hard to hear your first question, but I'll come back to that. Your second question, I think, was about the participation of members of the public in policy making. It's a very good question, because we elect our parliamentarians to do the work. We can't always expect that they will fulfill our wishes. They have their own, ideas, and people can reasonably disagree about things. I suppose there are innovative ways where often when we think of law reform, in Australia, we have law reform commissions or law reform bodies. They investigate the law, they prepare draft reports that are publicly available, and then they hold hearings. And so people can come along and express their views at a time before the commission has finalized its report. And this is the importance of participation. It doesn't guarantee that the government will do what you want, because there are many stakeholders, but it means you are heard. People who are never heard by government lose trust in government, and that creates tensions in society. So the model of law reform commissions that hold hearings and enable members of the public to express their views, I think could be used more widely by government in consulting with members of the community about public health law reform. Another thing that governments can do, they do this a lot in the United States, is they have what are called citizen-initiated referenda. So they have little referendums quite frequently. It's very unusual to hold a referendum in Australia, but sometimes where the government will say to the people, okay, well, we're discussing this particular issue, you decide. And so it's like a mini election, but on one narrow issue, and people can come and, they vote, and then the government decides according to the majority. So I suppose that's another way in which people can participate more directly in government. But I think your question it's a very smart question, because at this time, I'm sure in Indonesia as well as in Australia, a lot of people are losing trust in government. And so we rely on government for the health of the population. It's not something we can do ourselves. And so public health lawyers tend to take government very seriously. We believe in government. We want to strengthen good government. We're not anarchists. But as you say, it's important for the public to have opportunities to participate. Your third point about smoke from Indonesia, do you mean from burning? burning. Yeah, it's occasionally. Yeah, I mean, it's. I haven't seen it myself, but it sometimes comes on the news. I suppose it's an issue with Indonesia's relationship with Singapore, with Malaysia, more so than Australia. Yeah, I mean you can have a law about it, but that doesn't mean that you can actually stop the practice of burning. And often it is economic factors that are driving the practice. And unless you can create alternative livelihoods or better economic opportunities that don't involve burning, that don't involve widespread burning, then it's difficult to stop the problem. Yeah, it's an interesting point.
Okay, thank you for your show.
Professor Magnuson, I think Pak Sharofi's first question is about the evidence process during a case law in a lawsuit. Maybe if it's concerned about the health case law or health lawsuit, then how is the role of evidence in the court process? Is that right, Pak Sharofi?
Yes.
Okay.
Yes.
Well, I mean, we do have.
Can you give me a reason? How about in Indonesia and Australia?
So the comparison about the evidence
Australia, sir.
the case law, yes.
I would need to ask my my colleague Simon Butt about the law in Indonesia.
Yeah.
He is an Indonesian law expert, but I am not. But I mean, we have. I'm sure you're studying as part of the degrees. Students are studying medical malpractice law. Most countries have, in one shape or another, they have medical malpractice law, and we have a lot of medical malpractice law. It's civil law mostly. A lot of it is negligence law, where we argue that the doctor was careless and they injured the patient, and so the role of experts is very important in this area, because it's not so much, judges can't pretend to be medical experts, but they call in experts and they listen to experts and they then determine the case. But I'm afraid I don't know a lot about your evidence law in Indonesia.
Yep. Okay. Thank you, Mr. Professor Roger, for your answer.
Okay, thank you, Pak Sharofi.
Thank you.
Okay, I saw here that Burima has faced.
Okay. Can I ask something to Prof. Roger, Miss Aisyah? Okay, thank you, Prof. Roger, for your presentation. It's very interesting, and I want to know your perspective regarding the coercive intervention. We know any theory of public health law presents a paradox. The government, on the one hand, is compelled by its role of as the elected representative of the community to act the affirmative to promote the health of the people. To manage this rule requires vigorous measures to control obvious health risks. So, on the other hand, the government cannot unduly assault individual rights in the name of the communal good. So, health regulation that oversees in that achieve minimal health benefit with disproportionate human burden conflicts with ethical consideration, and it's not tolerated in a society based on the rule of law. So my question is, I want to your perspective regarding the coercive intervention. Does a coercive intervention truly reduce aggregate health risks, and what, if any, intrusive intervention make reduce those risks as well or better? That's my question regarding the coercive intervention truly reduce the aggregate health risks, and what do you think regarding that? Thank you, Prof.
Thank you, Dr. Rima. Coercion arises in many different ways in public health law, and we may feel more comfortable with more coercion or less coercion depending on the nature of the issue. I think we've all experienced COVID lockdowns, and so depending on your experience, you probably have your own views already about where the dividing line is, where things are reasonable and when they become unreasonable. And what we have seen has been this: when you look at countries around the world, some of them are adopting a more flexible approach. Others of them are doubling down and being extremely coercive. You know, in China, they're trying to absolutely go for COVID zero, and they will not be successful. You know, no one thinks they will be successful, and it's coming now at great cost to their economy. The approach that Australia took with that situation was that our states had very, very strict laws, far stricter than many other countries, but only until vaccination rates got up to a high level. I have had 4 shots personally. Most people, adults, have had an opportunity to have the 2 shots and then 2 boosters. And so at that stage, COVID is not going to be deadly. You might feel sick. I did get COVID, and I was sick for about a week, but it was not deadly. And so the government paid for the vaccines, and then people were also sick of the lockdowns. And so given that the population had reached a high vaccination rate, the restrictions were stopped. So there are some critics of what the government did. They thought they should have maintained some, perhaps not very high level of restrictions, but some restrictions. We don't even have mask laws now. I wear a mask often still on the train, but you don't have to wear a mask on the train. So it's become more a question of individual responsibility. So, the COVID one, we will be debating the coercive nature of the government's response for many years to come. Another interesting aspect of coercion in public health law, I think, is vaccination. And it's interesting because it's come to public, COVID has created a lot of concern about vaccinations. And yet, if you think of the most powerful public health interventions that have saved more lives than just about anything else, it's hard to think of anything more powerful and more beneficial to humanity than vaccination. And we all vote with our feet because we get our children vaccinated. That's the test of what you believe. Would you get your child vaccinated? And yes, I have got my children vaccinated, and I think others should too. But the question is, what do you do if someone has a belief, a mistaken belief, in my view, that vaccination is harmful? And that's a very interesting question. Do you make a martyr of that person? If they are forced, or their children are taken away and forcibly vaccinated, you may create more harm than good. Now, in New South Wales, in my home state, there is no requirement that parents vaccinate their children, but they can't send their child to childcare unless the child is vaccinated. And so there is a big incentive to vaccinate the child, because otherwise you're going to, just about everyone sends their kids to, if the parent has to work, they have to put their child in childcare at least for a couple of hours, a few hours a day. And they can't do that if the child is not vaccinated. So we have fairly good vaccination rates, but to be honest with you, in every country, it's not 100%. There's always a percentage of the population that takes a different view. And the best, public health experts in this area tend to say, well, you can't yell and scream and shout at people. That doesn't help. You have to try to create trust in government. That's why trust in government is important. And once you undermine that trust, all sorts of terrible things happen. People won't listen to government when government advises people to have vaccinations, for example. And that's why maintaining trust in government is so important for public health. Very interesting issue, Dr. Rima.
Okay. Thank you, Dr. Prof. Roger, for your explanation.
Okay.
Thank you for the question and the answer of Rima and Professor Roger. I also see here there's Pak Philippus. Please, Pak Philippus, you may ask your question now.
Right, thank you, Gisela. I enjoy your article, by the way. Great. Good morning, Professor Wilson. Thank you very much for your interesting lecture. Last month, I read that the next pandemic may come not from bats or birds, but from melting ice. So the viruses and bacteria locked up in glaciers could infect local wildlife and create a new, say, unforeseeable pandemic. So my first question is, how prepared are we in preventing this kind of pandemic? And secondly, I hope you will forgive my persistence on this pandemic issue, but restrictions and limitations during pandemic can be some kind of detrimental, especially by hampering the management of other diseases. For example, people with HIV or malaria or non-communicable diseases often fail to receive access to healthcare. Thank you very much for the coercion, quarantines, and lockdown imposed. Would it be possible to get a restrictions or lockdown system that is not hampering the access to healthcare for the future? I think that is my question. Thank you very much. Thank you, Gisela.
Thank you, Philippus. It's a very important issue that you've raised, the impact on non-COVID treatment of COVID lockdowns. To be honest with you, we know that there were deaths in Australia, in the United States, in other countries from non-COVID related issues because people couldn't access the treatment that they needed. At the height of the lockdowns, there were distressing cases about ambulances not coming and people needing emergency treatment. And so the COVID lockdowns got in the way of that. Now, just think about this. If you're receiving regular cancer treatment, for example, it may be, radiation, it may be chemotherapy. You need to be coming to the hospital generally, and a lot of that treatment was not possible. Another aspect of it, because of lockdowns, another aspect was that the hospital teams themselves were affected by COVID. And so massive pressures on treating doctors treating patients outside of COVID. Now we tried to in Australia have COVID-related clinics and everything else. So if you had COVID, you would go to kind of a special COVID clinic that did nothing but COVID. If you had something else, it was very difficult to actually go into a hospital because you had to answer all these questions and you had to show that you weren't infected. But it made it much more difficult to get regular treatment. And, you know, I have some personal experience myself with that because last year I fractured my spine, and so I was getting some treatment in hospital, and I know how difficult it was to continue to get that treatment, and I know how COVID, I can't think of a simple word, it decimated the healthcare the health workforce, because so many doctors and nurses were themselves sick at home, and it put far more pressure on those who were treating. So again, it comes down to trade-offs. How do you try to manage that? I don't think there are any answers, but I would agree with you that the desire to minimize COVID transmission also brought some unintended consequences because it interrupted treatment for other patients. And if something was non-emergency, if it was a non-emergency treatment, an operation, an elective operation, it just didn't get done. It didn't get done. So people were waiting, you know, a year or 2 years for something that they, you know, and life was very, very difficult still. But unless it was absolutely urgent, it didn't get done because of all the restrictions and lockdowns and the way in which COVID affected the health workforce. Yeah, very interesting challenge.
But yeah, exactly. Thank you very much, Professor. For my first question, I would like to your response on this. It's about the next pandemic that may not come from bats or birds, but from the melting ice, they say. So
from the what?
Melting ice.
Melting ice.
The glaciers.
Okay.
Glaciers.
Yeah.
From the ancient virus, the ancient bacteria that are for now is locked up in the glaciers. It could infect local wildlife and create a new unforeseeable pandemic, I think.
Mm.
So
I'm
how
not
do we prepare for this? Is there any mechanism or or some kind of code of preparedness to deal with this issue?
With SARS and with COVID, the discussion was all about the risks of animals and humans being too close together. You're raising a further risk that is really one of the public health risks of global warming. And many people would say, many public health advocates would say that global warming is the most serious long-term challenge to the health of humans, more than anything. And so we need to prepare for that in the way we prepare for other major challenges. We need to prepare at the international level. We need to comply with our obligations at the international level. We need to prepare for it at the national level. One of the biggest, I don't primarily work in global warming, but one of the, with climate mitigation or in that area, but one of the most interesting concepts, I think, is this idea of cross-sectoral governance. So because there are so many aspects to the problem, it needs to be a whole of government response. And you can't get a whole of government response to all the risks that global warming creates unless you have leadership right from the top. The health minister can't lead this. The health minister is in charge of the hospital system and the healthcare system, but this is not primarily a healthcare challenge. It's a survival of the species challenge, and so you need leadership from the highest levels. And so I think that's the challenge that we face as countries. Global warming needs to reach the very top of government, and every country needs to play its role. And we also need an effective international system, because countries are not separated from each other in the way that they used to be. Yeah, but I haven't heard a lot about melting ice. Yeah, I mean, I have heard what you said. It's a very interesting idea. I hope it's not true, but I guess we'll find out. Yeah.
Thank you very much. Thank you. Thank you, Gisela.
So, yes.
Thank you.
Thank you so much for the question, Pak Filipus. And maybe if I may add a little, we must be very excited to for the new accord that currently being drafted in the WHO for the preparedness of the next coming legal instruments drafted by the WHO. Okay, is there anyone else to ready to ask their questions? All right. Maybe I will slightly draw a brief conclusion about what we have learned today, Professor Roger, that again, the public health law that we have defined is public policy that influences healthcare, and it's actually beyond the practice conducted by doctors and nurses, and maybe it's not as easy as to limit harmful substances by raising tax, but also it also concerns in the population in general, and not only as individual. And as you said that your health and my health also relies on other people's health. And we have learned also about the source of public health law, which is coming from the legislation, international law, constitutional law, judicial decisions, and then the professionals and voluntary codes, guidelines, and codes of conduct. And maybe that's all from me. Thank you so much for the opportunity. Thank you, Professor Roger. And I will give back the forum to Mbak Nanda. Thank you.
Thank you.
Okay, thank you, Ms. Before we close our agenda, please all of the participants can turn on the video first to take a picture. Okay. Okay. 1, 2, 3. Okay, next. 1, 2, 3. Okay, thank you.
Thank you, Roger, for the presentation.
Thank you.
Thank you so
Prof.
much.
Roger.
Okay.
See you
So,
again.
okay. So allow me as a master of ceremony and all the committees to express our deepest gratitude to all of the participants. We always look forward to having a good cooperation in the near future. I wish you all a pleasant day. Thank you so much and good afternoon.
Thank you.
Thank you.
Thank you, Mbak
Thank you very
Nanda.
much.